All right. Good afternoon, everyone, and thank you for joining us for today's month of service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator for Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods. And joining us today, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Sapna Ayers. I'm sorry, and it does say Benjamin Daly here, but Sapna is filling in for other representatives with Lone Star Legal Aid for today, or with our regular presenters for this presentation. So thank you very much, Sapna, for being here this afternoon. But also included in our partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And A Month of Service is a collaboration of all of these organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We collaborated several years ago in an effort to create a greater impact, to reach more people, and to try and get as much information and resources out to the community as we possibly can. This virtual platform has allowed us the opportunity to reach even more people, not only within the city of Houston, but also surrounding counties and across the entire state of Texas. So do know that regardless of where you are joining us from in the state, that the information that does get provided during our presentations are relative to laws for the entire state of Texas. So it's not just for the city of Houston. So this is your opportunity to ask questions of our presenters who are experts in their fields, especially those as it relates to laws and legal services and needs. This is, however, information for informational purposes only. It is not to be considered any legal advice. Again, however, we do encourage you to reach out to our legal service partners should you find yourself in need of any civil legal assistance or need any additional information or assistance. So also do know that we do record our sessions as well as broadcast live on our social media platforms. And the presentation itself will be provided for those that have registered for today. Along with any resources that are made available or presented throughout the presentation that will be included on an email to everyone as well. If you are joining us on our social media sites, please feel free to type whatever questions or comments that you have into the comment section, and I'll make sure that it does get addressed, at the end of the presentation when we go over the questions. If you are joining us on Zoom, you have the opportunity to also type into the chat or feel free to unmute yourself and ask your questions at the end of the presentation as well. So without further ado, we're going to go ahead and get started with we're going to have Miss Cecile introduce first, and then we'll have Sapna introduce, and then we can go on into the presentation. So thank you all for joining us this afternoon, and hope that you all get the information that you came to receive today. There are so many eviction things that are going on right now. I know that there are a couple of changes in laws and processes and things like that. I'm not sure how much we can get into as of today, but well, I guess we'll kind of touch on that. That'll be one of my questions, at least, that we can try to figure out what's going on and what new and what's different, or what people can expect as it relates to the eviction process. So, all right, Ms. Cecile, why don't you go ahead and introduce first?
Sure. Thank you, Nia. Good afternoon, everybody. My name is Cecile Carlson. I am one of the coordinators here at the Department of Neighborhoods, and we are one of the A Month of Service partners. Very thankful to our presenting partner as well. Lots of really good and useful information. Like Nia said, unfortunately, times are tough, and we're seeing a lot of evictions happen. And one of the best ways that we can protect ourselves is to have the right information to begin with. So really, really appreciative and thankful to Ms. Ayers for being here today. And like Nia said, make sure to ask questions. Don't be shy. Just make sure to get the information. And if you need services or have any further questions, please contact our partners. And I'll go ahead and pass it on to Ms. Ayers. Thank you so much.
Hi, everybody. Let me share my screen here.
Iyer.
Yes.
I'm saying Iyer, Ayers. I keep saying Ayers. Iyer.
All right. Can everyone see my screen?
Yes, ma'am. You are
All
good to
right.
go.
Okay. So my name is Sapna Iyer. I am a director here at the Houston units of Lone Star Legal Aid. I'm not Kim or Ben, although they typically do this presentation. And we all do eviction work here in the Houston office. We are a nonprofit law firm with origins dating back to 1948 at one of our first legal clinics, and another legal services company in 1977. And we merged to form Lone Star Legal Aid. We are one of the 3 legal service organizations here in Texas. We are grant funded, so we do have grant guidelines and restrictions. And so in order for us to help you, you have to apply. You can apply 24 hours a day online, or you can call. And when we kind of get through the ends of the slides, we'll have the contact information again. But right here, LoneStarLegal.org is our website, and it's got all of the information in the various ways on how you can apply for services with us. So this is kind of the agenda that we're going to go through. It is a very basic, broad overview of landlord-tenant law. Most of it will focus on evictions. We will talk towards the end a little bit about lockouts, utility shutoffs, and security deposits. One of the things that Nia already mentioned was the new law. The new law does not go into effect until January of next year. So everything that we are talking about today will be true through the end of the year. And then in January, there will be updates to this presentation. All right, leases. So kind of the most important thing to remember is that your lease is a contract. It is something that you agree to do, and it is something that your landlord agrees to do. And your lease is going to control what happens with your apartment. Texas does allow for both oral and written leases. The lease will, like I said, tell you what is required between you and your landlord. But basically, as a tenant, it gives you the right to live there. If the lease is longer than a year, then you have to have it in writing. And again, your lease is your contract. You have the right to get a copy of your lease, and this is the Property Code Section 920024. With 3 days of the lease being signed by all parties, the landlord has to give you at least 1 copy. If you didn't get a copy of it, ask for that copy in writing. Remember, so much of everything is electronic nowadays. It's entirely possible you signed your lease on an iPad or a digital pad of some sort, and that all of your documents are in your portal. So make sure that you check your tenant portal to see if your documents are there that you can download and have a copy of. Read over your lease before you sign it. This is a general guideline for any contract. Read over it before you sign it. Make sure you understand it. Ask questions. For your monthly rent, when and where do you have to make your payments? Is there a portal? Do you have to bring them into the landlord's management office? Are there late fees? When are there insufficient fund fees? How are your payments applied? Typically, landlords will give you what is kind of called a 3-day grace period. I have heard over and over and over people say, my rent isn't due until the 3rd. That is actually not true. Your rent is due on the 1st. Late fees start on the 4th, but your rent is due on the 1st. How are payments applied? Almost always, if you are late or if there are other fees and charges, whatever you pay your landlord, they are going to use it to pay those fees and charges first, meaning that you may not have given them enough to cover your rent. You need to check the terms. If your lease is month to month, typically you will be paying a higher rent than someone who has a year-long lease or an 18-month lease. There are almost always going to be community rules and policies. You will see things about smoking, where you can smoke, where you cannot smoke, what time you have to be quiet, whether or not there is a policy for noise, for music, for example, parties, guests, all of those kinds of things. There are going to be addendums. So if you are on any kind of housing where you are getting help with your rental payment, typically this is HUD or the Housing Authority, you're going to have another agreement as part of your lease. There might also be concessions if you move in early. If they have a move-in special, they might discount your rent for 1 or 2 months. There are probably going to be several acts of default. The biggest one is always that the tenant has failed to pay rent. There can be things that are material breaches. If the only people on your lease are you and your child, and all of a sudden there's 4 more people living in your apartment, that is a material breach. Early termination or holding over. Again, your lease is a contract. It says the dates that you are agreeing to be in that apartment. So if you agree to be in that apartment from January 1st to December 31st and you leave early, you have broken your agreement. If you stay past December 31st, you have broken your agreement, and those are acts of default. There are going to be timelines in your lease. Whether or not you can renew, what time you have to give your landlord before you can renew. So a lot of times, if you want to stay there when your lease is over, you have to let your landlord know 60 days before your lease is over. So in the example that I just gave, if your lease is over December the 31st, sometimes by October 1st, you have to tell your landlord, I'm going to stay here. And sometimes on October 1st, your landlord will tell you, you cannot stay here. But there are specific times in your lease that say when those notices have to be given. Notice to vacate, your lease will say how many days notice your landlord has to give you. Almost always it's 3. It can be as short as 1. It will tell you if you are going to be entitled to notices of default. Things like, you left your trash out, or you didn't clean up after yourself, or you had an unauthorized guest, or you have a pet and you didn't clean up after your pet. All of these things are going to be defaults that are in your lease. Terminating the lease. So after the initial lease term, both parties have the right to get out of the lease. Your lease will tell you how long, how much time you have to let the landlord know if you're going to leave. So again, if your lease is over in December 31st, you might have to tell them October 1st, October 15th, October 31st, one of those days. I'm not going to be staying here. I'll be moving out on the 31st. If you don't leave when your lease is over, you are now a holdover tenant. Except in very special circumstances, you cannot make your landlord renew your lease. We have people call us and say, I want to stay here and the landlord won't let me. Most of the time, the landlord doesn't have to let you. Your landlord doesn't have to let you stay there, just like you cannot make your landlord let you stay there. So if you want to leave, you can leave. Your landlord cannot make you stay. Just like if your landlord wants you to leave, you have to leave. This is a contract. You agree to be there for very specific days. If you terminate your lease during the initial term, this is going to be an early termination of your lease. Your contract will say what happens when you do that, but typically there are fees and penalties, and one of those penalties might be that you still owe all of the rent for the rest of that lease because you agreed to pay it. Rights for early termination. So there are very specific times that you are able to get out of your lease early. They almost always involve some sort of family violence, stalking, or if the tenant dies. So these sections here, TPC is the Texas Property Code. These are the sections that are listed. If you are a survivor of family violence, you have the right to leave. You have to do very specific things. If you are a survivor of stalking or a sex offense, you also have the right to leave. And if the tenant dies, of course, they can terminate the lease. And if you're in the military, you can't control when you're deployed, when you have to leave. You might be deployed for 2 years. You have no control over that. So there are very specific instances where you are allowed to terminate your lease. The statutes are listed above, and each of those statutes require very specific things and what kind of documentation you have to give to your landlord. So if one of these applies to you, make sure you look at those property code sections and follow them to the letter. All of the Texas property codes sections that we list here can be found online. The Texas legislature actually has all of the various codes online. So if you just Google Texas legislature, all of the codes will come up. Another right to early termination, this is going to apply in the event of a disaster. Those of us in Houston, we are very familiar with disasters, unfortunately. One of the other unfortunate truths is that apartment complexes flood. Houses flood. So if the premise is totally unusable, meaning nobody can use it at all, and it is nobody's fault, like the tenant didn't do anything. So Harvey's the perfect example. If your apartment was completely flooded, the entire complex was completely flooded, the landlord has the right to terminate the lease. You also have the right to get out of the lease. If you think about it, this makes perfect sense. If the entire complex was completely flooded, nobody can live there. The landlord shouldn't be able to charge you rent for a building that nobody can live in, and you shouldn't have to pay rent for a building that nobody can live in. Now, if the premises are only partly unusable, and it again is not the tenant's fault. So let's suppose that there was some minor flooding, and the only thing that flooded was one of the bedrooms, but you can still live there, right? The landlord's doing repairs in that other bedroom, but you can still live there. You have the right to petition courts for a reduction in your rent. So if you had a 3-bedroom apartment and now because of repairs and flooding, you are down to 2 bedrooms, you can ask the court for a reduction in your rent. The landlord cannot kick you out just because your apartment is partially unusable. It has to be totally unusable, and that is an important distinction. And again, make sure you pull those statutes and read them and follow them to the letter. Each one will tell you what kind of documentation you have to give to your landlord. Now, if there is a breach means one party has done something wrong. So typically your lease will tell you what is a breach. We talked about this a little bit before, right? When your rent is due, what time of, if it's by midnight, or if it has to be dropped off at the office by 5, or if they have a drop box, those are becoming further and further, fewer and fewer between. How you have to pay. Does it have to be certified funds? Can you pay by EFT? Do you just log into your portal? Will they take a credit card payment? All of those things. If you don't do it the way your lease says you have to do it, then it's a default. If you have repeated violations of your community policies, so most apartments are non-smoking. If you're smoking in your unit, that's a big one. If you have a pet you're not allowed to have, also a big one. Your apartment will say who can live in there. You, maybe a spouse or a significant other, maybe a child, maybe a couple of children, depending on how big your apartment is. If you have people living in your apartment that are not allowed to be there, that is a breach. Part of that has to do with safety codes. It is not safe to have a 1-bedroom apartment that has 10 people living in it. If there's criminal activity by your tenant, occupants, or guests, so drug use, violence, those are things that we see the most. If you or your tenant or a guest even are doing these things on the property and even sometimes off the property, then they can evict you for that. And then if you stay when your lease is over, they can also evict you for that. The landlord has to give you written notice before filing an eviction. Okay. We will hear every so often someone say, well, my landlord didn't fix X, and so I held my rent. And I'm withholding my rent until my landlord fixes whatever needs to be fixed. A leaky toilet, a leaky faucet, maybe the oven doesn't come on or it doesn't really heat very well. In Texas, you cannot withhold your rent. Do not ever, ever, ever withhold your rent. As a tenant, you only have rights if you are current on all of your rent. So even if you have things in your apartment that need to be fixed, you still need to pay your rent. If you don't pay your rent, your landlord, more likely than not, will turn around and evict you for not paying your rent. And then, importantly, once you fall behind on your rent, your landlord doesn't have to fix your apartment. And also, once you fall behind on your rent, your landlord doesn't have to take your rent. So do not fall behind on your rent. If you're having trouble getting repairs, and this language in here is key, it has to threaten the health and safety of an ordinary tenant. So that kind of means what is wrong with your unit, right? Do you have a leaky kitchen faucet? Well, that's not going to threaten the health and safety of your household, right? It's just not. There's a difference if it's an overflowing, faucet and you've got water all over the kitchen floor and there's mold and those kinds of things. But if it's just leaking and it's draining and that's all that it's doing, that's not going to threaten the health and safety of your tenant. Now, if you've got sewage backup, that's definitely a problem. If you have a door that won't lock, that's a problem, right? That's threatening the safety of your unit. You're going to want to send a letter to your landlord by certified mail. You're going to want to tell your landlord exactly what is wrong with your unit. And then you're going to need to wait for your landlord to respond. And then secondly, really and truly contact a legal professional. The code lists very specific things that you have to do. And people kind of always do it wrong. And so again, if you withhold your rent, if you do this process wrong, you're going to be in more trouble than you were when you started, because once you withhold your rent, once you fall behind on your rent, your landlord doesn't have to fix anything. All right. So what if you try to pay your rent and the rent is refused? Well, now your landlord is breaching the lease agreement. Remember, your lease is a contract. You, tenant, are going to pay your rent on the 1st, and landlord, you are going to take the rent on the 1st. And so if you have tried to pay your rent on the 1st and the landlord refuses to take it, now the landlord has broken the contract. Now, landlords can refuse rent if you've already been late, or if you're only paying a partial payment, or if your lease has already been terminated. Okay. So if you've had your rent refused, one of the first things you should do is look at your lease and look at your ledger and make sure that you're actually paying the entire amount that is due. Remember, I said earlier that landlords will apply payments the way that the lease says that they can. And a lot of times the lease will let the landlord first apply your payments to any late fees or charges before they apply it to your rent. So if you have $200 in late fees and your rent is $1,000 and you turn around and give your landlord $1,000, you're going to be $200 short because the landlord took that money and applied it to your late fees, which means that you haven't actually paid all of the amount that is due, which arguably means the landlord doesn't have to take your money. So you're going to want to look at your ledger and make sure you've paid everything that you owe your landlord. You're going to document the date and the manner of the payment. Now, if you have a portal, this is a little easier to do because you can show that the landlord's locked you out of the portal. You do need to try to pay in person at that point if you can. Document any correspondence with the landlord. Make sure you keep the money available. I can't tell you how many times I heard people say the landlord wouldn't accept my rent, so I spent it. Do not spend the rent. You need to keep that rent money and be able to have it. So if the landlord turns around and tries to evict you, you can show the judge, look, I have all the money. It's sitting right here. They just won't take it. And continue to offer to pay your rent in full and on time. So every single month, go to the leasing office, go to the management office, and try to pay your rent. Take a witness if you have to, record it with your cell phone if you can. You need to be respectful, you need to be peaceful, you don't want to argue, you don't want to get into a fight. You just want to walk in and say, landlord, here's my rent. You want to record the landlord saying, I'm not going to take it, and that's it. Just turn around and walk out, and then you take that rental money and you put it somewhere safe so you have it. So when you go to court, you can say, Judge, I tried to pay for 3 months. They wouldn't take it, but here's 3 months of rent right here. All right. So in order to begin the eviction process, you have to get a notice to vacate. The notice to vacate has to give a 3-day notice, unless, I talked about this a little bit earlier, the lease allows for a shorter period, and the lease can allow for a 1-day notice to vacate. Proper delivery is in person, meaning they actually handed it to you. They sent it by mail, so regular mail, registered mail, or certified mail. They posted it to the inside of the front door. As an alternative, they can put it in an envelope, affixed it to the outside of the front door. If you get a notice by landlord on the outside of your front door, make sure you take a picture of it before you take it down. It is supposed to be in an envelope, which means it is going to be folded up. It should not just be a piece of paper stuck to your front door. The landlord has to prove up the circumstances as to why they stuck it on the outside of the door as opposed to opening the door and putting it on the inside of the front door. And if they are going to stick it to the outside of the door, they also have to mail it to you by placing it in the mail before 5 o'clock on the same day. The CARES Act is a federal law that says if you get basically federal money, there's a bunch of different programs, and this is kind of a broad picture, but basically if the landlord gets federal money, they have to give you a 30-day notice to vacate. So covered properties are, landlords that get money under VAWA, which is the Violence Against Women Act. The mortgage could be federally backed, so it's a Fannie Mae or Freddie Mac mortgage. It could be some sort of federal subsidized housing, like Section 8 or a voucher, HUD, rehousing. It could be a tax credit. There's a bunch of different kinds of federal funding that goes to apartment complexes. But if the complex is getting federal money, then they will likely fall under the CARES Act, which means you are supposed to get a 30-day notice to vacate. Okay, evictions. The primary focus is to get possession of the property. That is what an eviction is for. Landlord wants to be able to take the tenant out of the unit, have an empty unit that they can then turn around and rent to somebody else. The landlord has to prove they are the actual owner of the building. You'd be surprised how many times that comes up, right? When the owner might have sold the property and then the person bringing the eviction is not the current owner. They're not allowed to do that. They have to show that there is a breach in your lease. Typically, that is because you didn't pay your rent or you paid your rent late. They also have to show, another thing they could show is that the lease is over, right? The lease ended in December, it is now February, and you are still here and you refuse to leave. They have to show that they gave you notice. And they have to show that you refused to leave. So look at the day the eviction is filed, because if they're supposed to give you a 30-day notice and they file on the 25th day, that's too early. They're supposed to give you a 3-day notice and they file on the 2nd day. That's too early. So double check those. Landlords can ask for the amount of rent that you owe. So a lot of times you will see landlord is asking for possession, add back rent in the amount of X, 2 months or 3 months of rent or whatever it might be. Landlords can only ask for the rent in an eviction case. Anything else, late fees, utilities, other sums, they have to turn around and sue you in a separate lawsuit. So your eviction is for possession and how much rent you may or may not owe the landlord. You do have the right to ask for a jury, but you have to pay a jury fee. Justice courts have original jurisdiction over evictions, meaning every single eviction must start in the justice court. They have very simplified rules. They don't follow the rules of evidence, and they differ greatly from court to court. Make sure you are on time and you have everything that you need for trial. Courts differ, so some might call your name, some might say that you have to go up and check in with the clerk. Some judges will give instruction on how the court works before the trial starts. Typically, the plaintiff will start, meaning your landlord will start, almost always a manager of the property, and then you will have the opportunity to respond, at which point you need to be prepared to answer the judge's questions and to offer your own defense. Trial can be reset by motion of the plaintiff, but both parties have to agree. At the end of the trial, the judge will issue a judgment, or the judge can dismiss the case. Always get a copy of the judgment for review and for your files. Harris County Justice Court records are online. They have a portal called Odyssey, so you can put in your case number and your case will come up. Again, always be respectful to the judge, the court staff, and the opposite party. Some judges encourage settlements, and some judges will have mediators there to help you get a settlement. Both parties are going to agree to specific terms, but the parties decide what those terms are. So they can be things like, landlord will give a tenant 2 weeks to try to catch up on their rent, or landlord will agree to wait for rental assistance, or tenant will agree to move out by the end of the week and landlord will immediately dismiss the lawsuit. Make sure that whatever you agree to, that you can actually do it. I've seen a lot of settlements where the tenant agrees to do something, they agree to pay rent, or they agree to move out by a date, and then they can't do it and they're still there. Make sure if you're agreeing to something that you can do it. Settlements should be in writing, signed by both parties, and should be filed with the court. An informal agreement, you go outside and you make a handshake deal, the court cannot enforce that. So if you want the court to enforce the agreement, it needs to be in writing, signed by the parties, and filed with the court. And it might involve some parties giving up rights and may impose penalties. So sometimes the agreement will say the tenant, agrees to be out in 10 days as opposed to 5 days, for example. And if the tenant's not out on the 10th day, then the landlord can immediately ask for a writ of possession, which we'll cover in a few slides. So just make sure you know what you're agreeing to and make sure that you can do it. Do not sign a settlement agreement if you cannot follow through with the agreement. There is an appeals process from the Justice Court. You can appeal by filing an inability to afford court costs and fees form, which is called the IFP for short. You fill it out completely, you fill it out under oath, and you turn it back to the clerk. If you don't appeal, you have to leave within 5 days or the writ of possession can issue. Within 5 days of filing the IFP, and if the reason the landlord is evicting you is because you didn't pay rent, you have to make 1 month's rent payment into the registry. The case will then be transferred to the county court at law and assigned to a court. So you'll get paperwork in the mail letting you know your case has been moved, so make sure you check it. And if you have filed an IFP in county court, you don't have to file anything. I'm sorry, an IFP in justice court when you appealed, you don't have to file a separate answer in the county court. Your IFP that you filed in justice court is enough to be the answer in county court. Sometimes you'll get a letter from the county court saying you need to file an answer. And again, if you filed the IFP in justice court, you don't need to file another answer. If you have appealed and you're being evicted for non-payment of rent, you still have to pay your rent every month as your rent becomes due. That is typically the first of the month. So let's suppose that your eviction hearing is on the 15th. You have to appeal on the 20th. On the 25th, you have to pay rent because you're being evicted for non-payment of rent. And then on the 1st, you have to pay rent again. So sometimes this does mean that you will have 2 rental payments due pretty close together. If you don't make your rent payment, you might be physically removed from the unit, but your case can still be set for trial. Now, if you're in county court, the case is de novo, meaning it's from the very beginning. Whatever happened in the justice court is irrelevant. So you don't need to tell the county court judge what happened last time. It doesn't matter what happened last time. The only reason it's important is because you want to pay attention to know what the landlord says, because they might say it again in county court. County courts are formal courts, meaning all the rules of procedure and evidence apply. And so the landlord has to prove their case with testimony and with evidence. If you lose in county court, you have 10 days to appeal to the Court of Appeals. In Houston, this is the 1st or the 14th Court of Appeals. However, the writ of possession can still issue in 5 days. The cost to appeal from the county court is usually 10 times the monthly rent, and there's a lump sum. Some courts will let the landlord get an immediate writ of possession if you don't make your monthly payments. So when you appeal from justice court to county court, you still just have that 5-day window. And then when you appeal from county court, it is also just a 5-day window, okay? Appealing to the Court of Appeals is a much bigger deal than appealing to the county court, because the county court is a court of record. And when you appeal to the Court of Appeals, they are bound by what happened in the county court. They are bound by that record. All right, there are special cases, public housing, subsidized housing. This typically means when there is federal money involved, federal money is paying some portion of the rent. There is going to be a separate contract. It's called the HAP contract. There are federal regulations. There are CARES Act protections that we talked about, which says that you're going to get 30 days notice. And if you are on housing and housing is paying part of your rent, when you appeal, you only have to pay the part of your rent that you are normally responsible for. There are a bunch of different federal programs and the rules are all different. So this is just a very broad overview. If you're getting any kind of public housing assistance and you're facing an eviction, seek legal assistance. All right, what else could happen when the lease is breached? You can be locked out. Your landlord can shut off your utilities. Both of these things are not allowed unless there is some kind of emergency or there are bona fide repairs that are needed. Okay. For lockouts, if you're behind on your rent, the landlord has to put that the right to change the locks is in the lease, and the landlord has to give you notice. All right, writ of possession. Once your eviction is over, I think these slides might be a little bit out of order, so sorry about that. Once your case is over, generally, there's been a final judgment against you, it's been entered, and it's been 5 days. Your landlord can ask for what is called the writ of possession from the court. Once the court issues the writ of possession, you have very little time to move out of your unit, out of your apartment. The writ of possession is executed by the constable, and you'll get at least 24 hours notice from the constable before you're removed. Typically, that will be a sign on your door that the constable leaves there that says 24-hour notice to vacate, right? The writ has been issued. If the constable has to move you out, they can and they will put your belongings on a curb. They will change the locks. Do not interfere with the constable. The writ should not be executed if it's raining, and so they will wait until the next day. And if you lose, you really need to move. I understand that's easier said than done. But if you do not move by the time the constable shows up, not only will you be forcibly removed, you will also lose your personal belongings and things that are important and sentimental to you. So if you lose, start packing, look for somewhere else to go, look for a storage unit, look for some place that you can put your belongings. Because again, if the constable has to move you out, they will put your stuff on the curb and you will not be able to get it back. All right, sorry. Like I said, these are a little bit out of order. So we talked about lockouts and utilities a second ago. They're only allowed to lock you out if it's in your lease and they give you notice. They're only allowed to lock you out and shut off your utilities if there is an emergency and they're doing repairs. Even if you're behind on your rent payments, they still have to let you back in and they still have to turn the utilities back on. So you can go to justice court and you can file lawsuits in both of these situations. If you're locked out, it's called a writ of reentry. If it's a utility shut off, it's called a writ of restoration. You file in the justice court where you live. You can file the petition with that IFP that we talked about. And basically you're telling the judge, I've been locked out or my utilities have been shut off. Once you've been locked out, you need to request a key from your landlord. You need to call them and say, hey, I've been locked out. I need a key. And they are supposed to give you that key even if you have not paid rent. The whole purpose of the lockout is to get the attention of someone who is avoiding the landlord, to get the attention of that person who is coming in and out of the back window where the landlord cannot see them. It is not to keep them out of the unit. Once you file in justice court, you will get a writ of reentry ordering your landlord to let you back in the home. It is a hearing that is done without your landlord. Again, some justice courts will tell you to call the landlord first and say, hey, I'm about to file this. Sometimes they will order the constable to call them and say, hey, let them back in, right? But most of the time, you file this, you have your hearing in front of the judge without the landlord. The judge will give you a writ of reentry. You give it to your landlord and the landlord has to let you back in. There are damages if you have been illegally locked out. There is 1 month's rent plus $1,000 reasonable attorney's fees, minus any other rents or other sums. So depending on how far behind you are, this might actually even out your ledger. But if you're a couple of months behind, it's just going to cut the amount that you owe a little bit. There's also an option to terminate your lease. When the utilities have been shut off, it is essentially the same process. You file what's called a writ of restoration. You file it in your justice court where you live. It's an ex parte hearing, meaning it's just you and the judge. If you win, you'll get a writ of restoration. You give the writ to your landlord and your landlord has to turn your utilities back on. And there are also damages. A month of rent, reasonable attorney's fees, minus anything that you might owe to your landlord. Security deposit is a separate issue, but we put it in here because we get a lot of questions about that. Your landlord can deduct from your security deposit whenever there are damages to which you are responsible. So they're not supposed to charge you for normal wear and tear, but if you have put a bunch of nails in the drywall, or if when you were taking those drywall anchors out, you pulled out a giant hole in the wall, or if you made repairs that you were not authorized to make, right? So you tried to repair that giant hole that you made in the drywall, all of those kinds of things. They are allowed to deduct those charges from your security deposit. They have to give you an itemized list. And they have to return what is rest of the security deposit after 30 days after you leave. But before they have to give you that money back, you have to give them your new address. All right, so just kind of some tips. Talk to your landlord as soon as you have an issue. If you have anything that's coming up, talk to them, see if they're willing to work with you. Sometimes they are. Sometimes they're willing, if you get paid twice a month instead of once a month, sometimes they will let you pay them twice a month, right? Half of your rent on the 1st, half of your rent on the 16th. They might even be willing to put that in your lease because that is how you get paid. If you get Social Security and your check doesn't hit your bank, right, until the 5th, tell them that. Tell them, hey, I'm on disability. My money doesn't hit my bank account until the 5th. You know, can we make my payment date on the 5th? They might be willing to do that. So just talk to them. There is some rental assistance available, so you'll have to just check local organizations and churches. And if you're having issues with what's going on in your unit, right? You've got leaking faucets, you've got sewage backup, you've got an air conditioner that works, but your unit is still, 87 degrees. Pay the rent and then contact an attorney. Because again, those property code provisions can be kind of hard to follow. Thank you. Do we have questions? Nia?
Sapna, are you there?
Yes,
Okay, I'm sorry.
that's okay.
My screen like completely froze. It wouldn't let me do anything. And I was like, oh man, is it gonna cancel this whole thing and like shut everything down? Because it made some funky little noise, lines went across the screen and it did nothing.
Oh, I kept talking. I don't know if anyone heard me.
I am so sorry. I am so sorry.
That's
And
okay.
normally I try to log in on my tablet as well, just to make sure if something happens, at least another source is open. But I didn't. This one time that I didn't do it, of course, it gave me this heart palpitations. But okay, so um, my question for you. I know that there aren't a whole lot of different resources that are out there. And as much as we try to do these presentations to try to get as much information as we can out to people beforehand, I am still finding that a lot of people are just in just dire needs. Like there are no available resources out there, with the exception of contacting you guys. What other resources are available? Because right now people just need to get their rent paid, and that's what they're having problems with, which is paying the rent.
Right.
Do you know of any other services and things that are out there that are helping with rental assistance? Because we get those calls all the time.
I really don't. I know one of the justice courts, I'm gonna get it wrong. I can't remember which one.
I know it's one here. It was one of the Harris County. They have the thing in
Yeah,
the basement or something.
yes,
Yeah.
yes. So, and I don't even know that there's any funds available now at this point.
Hmm.
I think, yeah, it's just, I don't have an answer. Things are really tough right now, and there's just not that much assistance available. And whatever there is, it usually gets used up pretty quickly.
Yeah. Okay. There was another question that I had gotten that was emailed to me prior to. Let me go back to it. Um, there was a young lady that was behind on her rent. Um, Let me get her exact question here. She was behind on her rent. She submitted I'm just kind of giving you the synopsis because it was a very long paragraph that she sent. Um, she has submitted for the AC to be fixed. She has asthma. She has not paid her rent, but the landlord is basically telling her, uh, because it's not considered an emergency, that they basically won't or haven't fixed it until she pays her rent. Is that legal, or can they do that?
Um, so air conditioning is kind of one of those, as much as I hate to say it, it's one of those it depends answers. Um, right this moment today, they might be able to get away with it because it's not 120 degrees outside.
Mm-hmm.
I would say in the summer, no, they would not be able to. I think any judge would say, have you lost your mind? It's 100 degrees outside, which means it's 115 degrees inside her apartment. Turn the AC on. Right now, we're not in that situation. I mean, yes, it's muggy outside. Yes, it's warm. But I don't know that this level of temperature materially impacts her health and safety and welfare.
Even with asthma?
And again, I'm not a doctor, right? So that's the other piece of it. She would need to be able to show that it's the heat versus, let's say, the ozone or the pollution or the whatever impacting her asthma.
Okay.
And if she hasn't lost power versus air conditioning, right? Those are two different things. You know, you can do things to mitigate that, like buy a HEPA filter and put that in your unit to scrub the air to take the pollution out, which won't remotely impact the temperature. So that's why it's one of those it depends questions. Now, if it was winter, I would say the landlord doesn't have to fix anything, right? Even though winter in Texas is whatever, it's still not so hot that it's uncomfortable in your unit.
Yeah. Okay, let me see if I have anything else here. That was the only question that was on this list. Everything else you pretty much covered when I generally tend to try to ask a question that I know that I often get. Yeah, so with the change of the new effects that go into the first of the year, what is something that you recommend that most people, because I know a lot of people don't even know when I even try to tell people, oh, you know, that there's, you know, new laws have passed, the you know, things are going to change after the first of the year. Is there something that kind of shows these are the changes and this is what's going to happen as of the first of the year that we could potentially kind of get out to people?
Yeah, so actually Justice JP Wanda Adams, I believe.
Mm-hmm.
Let me pull this up because I turned off everything so I wouldn't be getting pinged over and over and over. She's having a training in her courtroom. And you know what, Mia, I can find that and send that to you.
If you could please, yes.
I'll find it and send it to you, but there is a training that she's doing on the new law. We are also working on updating our educational material. And so we will have like a new flyer, you know, kind of explaining the new laws. But let me find that. I want to say it's JP Adams. It is Wanda Adams's court. The new eviction process. It's November 5th. Let me send this to you so you have it.
Okay, and I'll make sure that it gets out to all of the participants that registered with this recording as well. And we'll probably put something like on our email blasts so people can kind of have a, you know, a link or something that they can actually see about and can potentially attend that training if they need to.
So I just sent that to you.
Okay. Okay. All righty. Okay. So with that being said, yeah, I don't have any other questions that are in the chat or anything. So I think that pretty much covers it.
Okay.
Well, thank you very much for coming in to fill in for them. It's always a pleasure just to see you anyway and just to catch up and to know that things are well with you. So thank you very much for that. So if there are any other presentations that we don't currently offer that you all may be interested in or need more information or resources about, please feel free to reach out to any one of our partners and let us know. We are in the process of planning for 2026 So again, if there are any other pertinent topics or anything like that that comes up, and I just got State Bill 38. So I will definitely make sure that that gets sent out along with the link of this presentation for everyone to go back to view and or to share with other people that you know that may be facing eviction, or going through some kind of financial difficulty or issue with their landlord. Then please tune in and share that information, because again, a lot of people are still really going through it, and rent prices are getting so much more expensive. It's getting harder to even qualify for rent. Most people want, most landlords want you to have at least 3 times the amount of the income to even qualify for a new, um, you know, for average rent. And the cost of average rent is just absolutely ridiculous. I don't know if there's if any kind of law, let me praise be to the gods, that somebody could put some kind of a cap or something on what they're charging for rent, because the rent these days are the cost of a mortgage. There's no way anybody can even qualify for some of these, what these requirements are. Oh, you know what I want to ask too, real quick. At one point, I think I had asked Benjamin or Kim, I can't remember, were they going to talk about, as far as people qualifying for rental properties, how far back that you can go back and look at somebody's history? So if somebody's got like a felony conviction from like 20 years ago, can they still be disqualified or not eligible for particular units according to, whatever rules that the property management sets up that will deny them from having access to
So
certain housing?
private landlords, I think, can go back as far as they want.
Mhm.
I
Sorry.
don't know how far back just a regular tenant screening goes. I
Mhm.
would be surprised if it goes back 20 years. That seems rather far, but private landlords can, yes, they can absolutely go back and look and see how far. There was some guidance that HUD had, or I think anything older than 10 years they weren't looking at. But
Okay.
and I'm not certain if the guidance has changed in the last year, so I would have to double check that. But I think 10 years is kind of generally a safe line. There's some other statutes where 10 years is kind of the cutoff as far as relevance.
Okay. Okay. All right. I just thought about that. But
Yeah,
again, thank you very much.
of
I really
course.
do appreciate you
Of course.
for coming in this afternoon. For anybody else, you guys, please have the opportunity to join us for other month of service presentations. I'm trying to finish up my November calendar, so if I have that completed in the next day or so, that will be included, so that you guys can potentially join us for events that we've got coming up next month. I know we've only got 2 more left for this month, and that's for property taxes and for foreclosure. And if those folks are on here looking for eviction assistance, they certainly don't need the foreclosure part. So, but if you guys know of anybody that needs any assistance with property tax exemptions and well, actually, yeah, the top property tax bills are going to be coming up within the next few weeks or so. They're going to be started sending those out. So if you guys know folks that have property taxes that they have to pay, or potentially facing foreclosure, since those folks are also facing eviction, then you might want to tune in for those presentations as well. So thank you all very much again. Hope you have a wonderful afternoon. Oh, Cecile, do you want to talk about coffee and conversation real quick? We've got that coming up.
Sure thing. Thank you, Nia. Yes, we want to invite everybody to come to our resource fair that we're going to have on Thursday, the 23rd at the Palms Business Center. That is 5330 Griggs Road. We'll be there from 10 to 12. A lot of the AMOS partners will be there as well. So if you guys want to either apply for services or just meet us and get a little bit more information, we'd love to have you guys there. Again, that is our resource fair. It's going to be this Thursday at the Palm Business Center, 5330 Griggs Road, from 10 to 12.
All right, cool beans. All right, thank y'all very much. Y'all have a wonderful afternoon. Stay safe, and we will see y'all next time.